It's Wednesday. It's May 7th. It's day 10,000. No, it's not. It's day 11 of the Karen Read case. And I actually went back and looked through past court hearings to see how long the Commonwealth said that their case in chief would be. And the Commonwealth said that they believed their case in chief would be about 3.5 weeks. They were trying to keep it under 4 weeks. They were optimistic for 22 to 24 days. We're like more than halfway through the Commonwealth's case in chief, and there's a lot of witnesses we haven't seen. For the jurors, it's not, I think, a glaring and obvious, where are these witnesses yet? But for us, it is becoming a glaring and obvious, where are these witnesses? The rumors are true. Today is in fact my birthday. Do you guys know what I did last year on my birthday? Do you want to know? Yeah, we streamed the Karen Read case. That's exactly right. We streamed the Karen Read case. That's what we did last year on May 7th. On May 7th last year, we were on day 6 of the Karen Read trial.
Then Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
He could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
You attended the autopsy of John.
If he's been on the job longer, does he have more experience? I don't know what the fuck that guy was doing at work, but honestly, fair. The fact that Yanetti is not asking questions at 1,000,000 miles a minute at this point, as this witness is getting more displeased with being asked about Proctor, is truly a credit to Yanetti. Yanetti has been able to rein in what I imagine at this point is his own glee, because Yanetti's just got a fish on the line at the moment, and you can't get overexcited. You can't start reeling him in too fast.
You attended the autopsy of John O'Keefe on January 31st of 2022.
I did.
And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office?
What?
The medical examiner's office in Sandwich.
The lead investigator didn't attend the autopsy, which is unusual in a normal case, unless the lead investigator is, I don't know, out on maternity leave or in the hospital themselves. Like, the disrespect, not only did the lead investigator not go, but the lead investigator's partner didn't go. Like, robbery, homicide would never. I can't even, by all good investigative techniques, this is still an unknown death that's being investigated of a police officer. And not just a police officer, but somebody who the community is aware of, whose family tragedies were well known. And you don't go to the fucking autopsy? And generally, with the death of an officer, you would often also have a district attorney at the autopsy. There were a lot of times DAs went to the autopsy. And we did a lot more fucking autopsies than y'all did. We learned some new information on day 11 of the Karen Read trial, and somehow I find myself continuing to be more and more perplexed, even though we have seen this trial once before together. We have seen the pretrial motions, and yet new things are illuminated. The morning started with Trooper Connor Keefe, who is a more junior state trooper, it seems, but was real salty, in my opinion, when asked about Trooper Proctor. I think that Yanetti did a good job on cross-examination in using the cross-examination of this particular trooper to highlight how involved Trooper Proctor was, to highlight again that Trooper Proctor is the lead investigator. I wonder if the jury's asking. We haven't heard from Trooper Proctor. They also brought in the physical evidence collected at 34 Fairview during the search on January 29th, 2022, that was found after 5:45 p.m., the pieces of taillight and the shoe. There was an objection because one of the evidence bags was marked as 2 pieces of taillight, and there was like itty bitty little piece. Brennan was asking if it cracked off of something, and the defense is like, no, that evidence bag says 2 pieces. This is now 3. I remember that coming up last trial, but this trial, Brennan was like, can you just take it back and secure it into evidence with you? And I'm like, what's he going to put in his pocket? So the court reporter handed them an envelope and they marked it for identification as marked for identification BB. And I was like, it's a little bit. It was the tiniest little thing, but how the heck did it get broken? If it got broken once it was in the evidence bag, they're going to have to ask the lab about it. But we have those pieces of taillight that were recovered at the scene on January 29th, and then the shoe that was recovered. Those all were shown physically to the jury today and are now in evidence. And then we got into questioning about John O'Keefe's autopsy. I do not remember this line of questioning previously. And Connor Keefe, the kind of more junior detective on this team, was the one who attended John O'Keefe's autopsy, not the lead investigator, Proctor, and not Proctor's partner, Trooper Bukhenik. Neither of them attended John O'Keefe's autopsy, and I had not remembered that fact. And if they talked about it last time, because so much came in with Trooper Proctor that was new information to me, it did not register with me that one of the more junior members of the team was sent to the autopsy like, just go watch the autopsy. In a lot of homicide cases, it is the lead detective or their partner. And when you have an unknown death of an officer, it's surprising to me that the lead investigator would not attend the autopsy. After we get into Trooper Proctor's text messages, though, that might be a better fact for the Commonwealth. We'll see. It was surprising to me, though maybe it shouldn't be surprising to me, the things that have gone on in this investigation. And then the Commonwealth's next witness was Jessica Hyde, or is Jessica Hyde. They are just finishing direct examination at the lunch break before we get to cross-examination with Attorney Alessi. But before we got to that witness, there was a break for argument with Attorney Alessi, Brennan, and the court over what Jessica Hyde could be cross-examined with. Alessi was asking to introduce a certified copy of a court ruling after a Daubert hearing where Jessica Hyde was the expert in Maryland. The argument was that that ruling should be able to come in as evidence. That physical certified copy of the ruling should come in as evidence in this case, and that he should be able to question her about it on cross-examination. At the end of that argument, the court went and read, I think, the entire opinion, came back out after a substantial break in the morning, and then made the ruling that Alessi would be able to question about it on cross-examination, but that the case itself, the physical case, would not be marked into evidence, which I think is the right call because it's not evidence in this case. It is proper grounds for cross-examination. And then Jessica Hyde, who we saw last trial, took the stand to talk about the tab activity and search activity on Jen McCabe's phone, and to talk about whether or not searches were deleted off of Jen McCabe's phone and whether or not phone calls were deleted off of Jen McCabe's phone. And that's where there was some new information for me. But as we got to the breakdown of how the tab time works versus search time, they brought up a chart that showed that Apple predictive search was starting to populate at 6:23:49. When the defense expert testifies, we will hear more about that cache record of the Apple suggested search term. And the Apple suggested search term at 6:23:49 a.m. was, how long does it take to digest food? And then we see recent web searches pulled up after that, showing recent web searches at 6:23:51, 6:23:57, and 6:23:56 that are all from different artifacts and put together. She explained which artifacts they were from, but those were different artifacts in different databases on the phone, and all of those at that 6:23 time frame were the how long TI die in CIKD search. And then went into discussing the how's long search, which came from two different artifacts in the phone at 6:24:18 and 6:24:47. So they say from Google search and recent web searches, the timestamp on those searches is 6:24:18 to 6:24:47 a.m. And that the 2:27 is the time of the tab, which we have heard from the prosecution's experts before. And we know that the defense experts refute that. This expert says the time when the tab is opened and when the other searches were happening, like Hockamock Sports, etc., that if it stays open and the tab is left open until the tab is closed, it does not write. And when it writes into the file, it writes the time that the tab was open. That is consistent with what the prosecution has said and what their other expert has said. I believe that we will see different testimony when we get to the defense expert. And then we got into the whether it was deleted or not. This expert said that the user could not delete that hows long search, that it goes into the WAL file, and different programs can express things that are in or removed from the WAL file differently, and was explaining how different programs express that differently. And when you dig deeper into the records, that is not a user deletion. And her expert opinion was that that was not a user deletion because that is not something that can be user deleted. Again, I think we will see a different explanation of that from the defense expert, but I find this expert easy to follow and understand. Whether or not the jury ultimately agrees with her opinions or not after they see all the tech experts is up for them to decide. The thing that was most notable to me with the discussion of Jen McCabe's deleted calls, and we know from Jen McCabe's testimony, the defense is talking about what Jen McCabe called inadvertent calls or butt dials to John O'Keefe in the after midnight hours of January 29th, 2022. The explanation for those not being deleted from this expert is that the phone stores 200 records for different types of calls. A FaceTime video call will store up to 200 of the most recent records. A FaceTime audio call will store up to 200 of the most recent records, and phone calls will store up to 200 of the most recent incoming or outgoing phone calls. And from January 29th to when Jen McCabe's phone was imaged on February 1st, Jen McCabe's phone had made over 200 calls. So as the 200th call came out, the last one in time of that 200 was overwritten by the system. And the last of that 200 that they had at the time her phone was imaged was from 8:29 a.m. on January 29th. So between 8:29 a.m. January 29th and when Jen McCabe's phone was imaged on February 1st, there were over 200 incoming outgoing phone calls. I thought that number was significant. I think that it is a lot of phone calls. And I think if the defense is going to argue that Jen McCabe was at the center of who was talking to who, 200 phone calls in a bit less than 3 days is a significant number and might be more significant than arguing about whether there were user deletions of those calls to John O'Keefe. I don't know if the defense will see it that way or argue it that way, but I found that 200 phone call number to be notable and surprisingly a lot of calls. Should I have been surprised? Maybe not, because we know that in Jen McCabe's testimony, she said when the FBI wanted to talk to her, she said, I need 10 minutes, and promptly made 5 phone calls in under 10 minutes and only disclosed 2 of those to the FBI and said she forgot to tell them about the other 3. So when the defense gets into their tech expert, I wonder if they will bring up Jen McCabe's call logs, phone logs, or phone records from the cell phone carrier if they have them. Alan Jackson, in his cross of Jen McCabe, said that the reason they knew about those calls to John O'Keefe were from John O'Keefe's phone. So I do not know if they will have those corresponding call log records, but 200 calls I think is a significant number, and we will see if the defense argues that. But also, it might go to the prosecution's point. She did not use or delete those phones, which is consistent with what she said. In fact, she was so talkative on the phone that they deleted off the phone because there was literally not enough room in storage for the amount of phone calls that were incoming and outgoing in the days immediately following John O'Keefe's death. Cross-examination of Jessica Hyde will take place after lunch with Attorney Alessi. I'm very curious to see where we go with that, especially after the argument that he made before lunch that there was a court finding when Jessica Hyde was the expert, finding that some of the proffered expert opinions were not allowed in to evidence in another case in Maryland because the specific location did not have access back to the Apple algorithms and the proprietary Apple data. And because that was not accessible, the court found that that information could not be testified to by Jessica Hyde. We will see how that comes up in cross. I'm very interested to see how Alessi approaches it.
All right, jurors. As you know, I think I told you in the beginning, one of my functions is to make sure that a case is tried fairly and efficiently and not to waste anybody's time. So if I get frustrated at lawyers about something, I try not to, and I don't think I aim.
Oh.
If I seem to cut somebody short, the lawyers are just doing their job. When they request sidebar conferences, they're just doing their job. I am going to try and keep all sidebar conferences to a minimum, but the lawyers are just doing their job. Okay. All right, go ahead, Mr. Alessi, fill in the witness.
It seems that the defense is like, Your Honor, you have to stop making comments. Earlier today, Alessi had asked for another sidebar, and she's like, Mr. Alessi, last one, or something of that nature.
What is your opinion about whether the phrase, "how's long to die in cold," was made at the time of the timestamp 22740?
It's the last time, Mr. Alessi, on this issue, okay?
The reason I think the two are connected is she said, I'm going to try to keep sidebars to a minimum, but the lawyers are just doing their job. I think the defense asked her and said, Your Honor, you can't do this. Jurors just kind of look at judges like doing their judge stuff. Lawyers will interpret that in a different way than jurors will. And lawyers will worry, I think, more that jurors will be like, oh, they must be doing something wrong, than I think jurors actually interpret. It doesn't sound very loud because she's not at the mic, but she said to them, look, the lawyers are doing their jobs. I want this case to move forward and move forward smoothly. And I want to keep sidebars to a minimum.
You were asked when you began working on analyzing phones in this case, and you said it was in May. Was that of May of 2023?
May of 2023. May 4th, 2023 is the email I have of a note. Thank you. Yes. It's easy to remember because May the 4th be with you.
When you first were asked to begin work on this case in May of
100% May the 4th be with you. Brennan's like, what the fuck are you talking about? I like that she's laughing at her own joke. And Brennan is like, the fuck? At the end of Miss Hyde's testimony, there were points of the cross-examination that I just don't know where Attorney Alessi was going with his questions. We did not get into the 200 phone calls nearly as much as I had hoped that we would get into. We got a lot into whether or not multiple tools are used, and Alessi asked a lot of questions about Celebrite changing their reports so that their reports, if you are looking at the same artifact as in their reports prior to and during the last trial, those reports would have indicated a 227 timestamp. Those reports now would not indicate that same timestamp, though the Axiom reports would still reflect that same timestamp with an explanation. This witness explained the difference in those two. They had asked Ian Whiffen from Celebrite about that a bit, so that's not new information. It was just rehashed quite a lot in this conversation. Did we get all the way into the defense's theory of the 227 tab movement or Google search? No, we didn't. Did the defense lay foundation for what they will likely argue with their expert? I think so. We also saw them asking about whether or not John O'Keefe's phone was secured in their cross-examination. Was John O'Keefe's phone put in a Faraday bag? Was it put in airplane mode? Was information still coming in? And she said, yes, we still saw SMS messages and ring notifications coming into John O'Keefe's phone, and there's no indication that it was secured in a Faraday bag that would block signal from coming into the phone and providing new information to the phone. So she said it does not look like this phone was secured in that way. We have not seen the law enforcement that secured John O'Keefe's phone after it was given to them by Carrie. We will see when that comes in, like when, if. That was a lot of a cross-examination. Let's see where the court goes after this witness is done. But at the end of the day, her testimony from before lunch, was it clarified a ton in cross-examination? I don't think it was clarified a ton in cross-examination. I don't think that her testimony differed when Alessi said, so you used multiple tools. Yes. So it is particularly undetermined as to which tab movement caused that timestamp, whether it was the tab being put into the background or the tab being opened or the tab coming into the foreground, which she didn't testify to as much in this case. She said tab movement and didn't define the type of movement, but I don't think that's inconsistent to say tab movement and not list all of those tab movements. So we will see if there are things from this cross that get to the defense's expert. What I thought was the most interesting part of cross at the beginning was when Alessi was asking about her report that said the last user interaction on John O'Keefe's phone was at 12:20, and he pulled up Ian Whiffin's report that showed that the phone of John O'Keefe was locked with a button click lock after 12:30, and I think the exact time was 12:32, and showed that after 12:20 there was a Face ID unlock of the phone. I thought that was very early on in cross, but I thought that was really one of the more interesting things in cross, that she said the last user interaction on the phone was at 12:20 in her report, but Ian Whiffin's report shows a Face ID unlock. Is that not a user interaction? So we will see. I thought that was the most important part of cross. It got lost in all of the conversations about Celebrate. I think the most effective cross may have been the 200 calls. Her report says that the user interaction on John's phone stops at 12:20. Whiffin's report says that it is well into 12:32, that 12-minute gap. Why is she not indicating Face ID as a user interaction? Why is she not indicating a button click as a user interaction? I think those are fair questions. And it didn't come up on redirect at all because I think the point got lost. Maybe it will come back around in closing or in other expert testimony. But I think locking a phone with the button, I don't know how you don't consider it a user interaction. And she said that she had that data and did not consider that data, which is also something I was curious to see followed up on redirect and did not get followed up on. I think that cross could have been tightened to the things that are contradictory, and that timeline was contradictory. And I think John O'Keefe's phone not being secured, we will see come back up again with the defense. We're just not there yet.
Absolutely more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
That was a really good use of clip. I'm not mad about it. It's going to depend on how the jury feels about Jen McCabe, but Brennan is going to use that to argue Karen Read's team is pointing at Jen McCabe because Karen said, either you're going down or I am. The defense can argue for more completeness. They can't clip or edit sentences, but that is the complete clip. The jury might want to see the entire thing. What was asked, what was said, but it is a complete sentence. And the defense cannot use clips from any of her interviews. The only way the defense can put in more information is to either argue completeness with the prosecutor or have her testify. Those are the only two options. The prosecution can choose what they put in and what they don't, and the defense can't submit other clips. Because when the defense goes to submit them, it is their client's own statement which is hearsay without an exception. When it comes to the prosecution putting them in, they are statements of a party opponent. And so the prosecution can use them. When they say you have the right to remain silent, it is because you have the right to remain silent. And the jury is going to be very tuned in to Karen Read's statements. It is one of the most relevant things to them. How they interpret them is completely different. How they interpret them is up to them. But they are going to pay a lot of attention to that. I wonder if the prosecution is thinking if they use enough of these clips, it might force her to testify. That they are seeding enough clips into the trial that she might feel that she has to testify, or she will feel that, and we can't guess, she and her legal team will know, it might be that they think there is enough context, because there are statements in front of the jury now that they did not have last time that I think add context, but there are statements that are very unflattering. Can the jury ask to see more? They can ask, but they're not going to get it. Can the jury go watch the docuseries over the weekend? No, they would need to disclose that to the court. They can't. I don't think the interviews are a good look. But by the time we get to accident reconstruction and Trooper Proctor, will the interviews matter or not? We're going to have to wait and see how that information comes in. But they are putting these in early on, and it changes the jury's perception of a defendant because they are hearing her words. That change could be good. That change could be not good. And that can shift. Jurors' perceptions will shift over the trial. They are told to keep an open mind till all evidence comes in. And I just have to wonder if by the time we get for Trooper Proctor, the jurors throw up their notebooks and are like, what the fuck is this even? I don't know. And it's hard for me to separate out what I know. But at this point, the prosecution has put in a stronger case than they did last trial. That's my perception of it. Does that mean it is a strong case? I don't think we're there yet. But they have put in a stronger case than last time. Will that blow up on them when we get to the coroner, the accident reconstructionist, and more? I think last trial, the accident reconstruction testimony is some of the worst testimony I've ever seen of anything ever. And that includes coroner armpits. So will the jury feel like all of that was buried at the end? Or will it be predominant in their mind? But the way they're presenting evidence is much stronger. We're at the end of day 11. The jury was released a little bit earlier, and the next witness is going to be a longer witness. So I wonder if it is one of the other experts, accident reconstruction, medical. I know the Commonwealth has a expert with regard to the injury to John O'Keefe's arm. So we have a couple experts that we have not seen. And it is starting to loom pretty large that there are a lot of civilians that we know we haven't seen, and will we see them? The Commonwealth said that their case would take about 3.5 weeks. We are at Wednesday of week 3. So does the Commonwealth have about a week left of trial? Maybe. Maybe we do. I'm real interested to see where we go from here, because it is a very different trial the second time around. And I'm shocked that there's still new information. Every time there's new information, I'm like, how is there still new info? Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.